Hello, everybody. Adam Parks here with another episode of Receivables Roundtable. Today, I am here with industry titan, Mr. Manny Newburger from Barron Newburger Law Firm. How you doing today, Manny?
Doing fine, thanks, Adam. How are you?
I am doing fantastic. I really appreciate you taking the time to kind of join me here today. I know we've got kind of an interesting hot button topic, talking a little bit about Hunstein and how that has evolved since the original ruling came out. Not that there's anybody listening to this podcast that's not familiar with you as an individual or your firm itself, but can you give anybody out there just a little bit of background on yourself and kind of the firm?
Sure, be glad to. We're a multi-state firm. We handle cases for the financial sector across the country, and I do consulting work around the world, working with call centers outside the U.S. as well as within. Our chosen sector is consumer financial services. We do a tremendous amount of work in that space, primarily defense and compliance, but also regulatory work. So I'd like to think we're a full-service firm in the financial services space.
Well, you guys are Manny's a frequent speaker on podcast webinars at just about any conference that I've attended in the last 15 years or so. So I really appreciate you taking the time to kind of chat with me today.
Well, thanks for inviting me. I hate to say it, but the experience goes with the gray hair. I did my first fair debt case in 1982 when I was still a third-year law student. So I've been working in this space for a long time.
Understood. So, I'm curious to get your take. I mean, obviously, everybody who's watching this would be familiar with the Hunstein case in general. But I wanted to kind of get your thoughts on the evolution of this case and kind of where things have started to head, especially as it comes to a lot of these copycat lawsuits that we've started to see.
I think that's a great question. We've now got hundreds of copycat suits filed around the country, some in state court, some in federal court. And the cases are reaching a point where they cause some really important decision making for the defendants. And with this decision making goes a point that I made in a recent article. The industry has been cheering all these Article 3 cases that are throwing cases out of federal court. And you may know this. There's a judge in New York, Judge Brown, who on a single day tossed 5 Hunstein cases out with a single order, saying no Article 3 jurisdiction. Everyone cheered, thought this was wonderful. Well, guess what? Those suits have been refiled in state court. I don't know if all 5 have been. I think at least 3 of them have been. Mm. And, it's interesting to me. If you go back about 15 years to around 2006, the business community knew really well that it didn't want to be in state courts. So much so that the business community lobbied for a law known as the Class Action Fairness Act, or CAFA as we call it. And the whole point of CAFA was to make it easier to get out of state court and into federal court. And there are congressional findings that go with it that talk about the difficult time that businesses were having getting fair treatment in state courts. And if you're at all curious, there's actually a judicial hellholes website that I think the American Tort Reform Association publishes. You can go there and look at some of the places that they say are places you never want to be. And so to get out of these judicial hellholes, the business community lobbied and got through this Class Action Fairness Act. Only here we are 15 years later, and everyone seems to have forgotten all the reasons why that happened. And they've all forgotten that we don't want to be in state court because we're right back in those places where we don't get the same level of fairness and the same level of judicial independence, because in state courts we're often dealing with elected judges as opposed to those who are appointed for life and no longer subject to political pressures. And so I think that everyone who's cheering about their cases getting tossed out of federal court might want to pause to think about how they're going to enjoy being in state court. And once your case has been tossed for lack of jurisdiction, you're not going to get to put it back in federal court. So one of the interesting questions in a lot of these cases is, what do we say about jurisdiction? And this is an important discussion that we tend to have with clients. And of course, my position is that at least for the moment, the Hunstein case says that if you make the allegations that are the heart of that case, you've at least sufficiently pled Article 3 standing to stay in federal court. So my position is that whether or not they ultimately prove they've got Article 3 standing, at least at the beginning of the case can be in federal court. So I'm not rushing out and trying to get cases kicked for the most part. Keep in mind there's no one size fits all. There will certainly be exceptions where we will move to dismiss a case for lack of Article 3 standing. But for the cases we know we're going to fight substantively, especially class actions, we're not in any big hurry to do that. And as recently as this week, one of the judges in the Northern District of Illinois in federal court in Chicago, Judge Coleman, issued 2 orders denying the plaintiff's motion to remand. And again, this is a fascinating issue. So not only do I think the defendants don't want to be in state court, but a number of the plaintiff's lawyers clearly agree with me. And so what's happening is these cases are getting removed to federal court, and plaintiffs' firms are saying, no, we didn't allege that our client has any actual injury in fact, and there's no basis for federal jurisdiction. You should send us back to state court. And we're seeing this. We've seen it in Florida. We've seen it in Illinois. I know it's been done on the West Coast as well. So you've got these battles going on about just where will we have the fight. And I can't give legal advice to your audience. This is a podcast. There's no client relationship. But I'll say this. There's no one-size-fits-all answer to any of this stuff. And anyone who tries to create a one-size-fits-all answer is going to probably regret it sooner or later. Every case has to be looked at to see what you want to do. So that's at least the first big thing we're seeing. And another one that goes with this is if you've got 12 or 13 or more class actions against you around the country, is it time to talk about a multi-district litigation motion and try and get all the cases sent to one court to manage them? And of course, that raises the question of do you want to put all your eggs in one basket? Mm-hmm. Only have one judge who's making the decisions instead of taking the chance that maybe even if you have one judge who doesn't like your case, others might. Mm-hmm. And with that, frankly, there's been the question: well, do you just let one of these plaintiffs' lawyers certify the case? I was talking to a client this week. I said, look, it'd be kind of fun, Judge. We disagree on liability, but we agree there's one letter at issue here. There's really one legal issue. Go ahead and certify the class. Let us have a contested trial after they give notice and see if the plaintiff's lawyers want to pay to give notice to 2 or 3 million people, and see how they like that burden. So the problem then, of course, is you've agreed to put all your eggs in one basket by letting one judge hear it. So this question of where and how do you fight is very, very important. And it has little to do with the substantive issue of Hunstein. It has a whole lot more to do with the larger picture of litigation strategy and litigation management. Mm-hmm. And there are an awful lot of factors companies have to take into account when they're making these decisions.
So, as I've looked at Hunstein, and, I think the original claim of the plaintiffs was basically that, it's harmful to consumers that we're using a letter vendor, or a third-party servicer at all in some instances. I'm curious to get your take on the reality of that situation. As an operator, it's been my experience that there's benefits to using specialists for different functions within your business. How do you kind of look at that piece of this situation?
First of all, I agree with you. I think that, there's sort of this assumption that people are using outside vendors because it's cheaper. I'm not convinced it is. Agreed. I think what the outside vendors do is they provide levels of compliance that would be difficult to manage internally from start to finish. I remember the old days. I actually remember defending a case where I had a client in Pennsylvania who never sued in New York, sent a letter to a debtor in New York, and their letter said, this is not a threat of suit, but unfortunately one of their idiot collectors rolled the letter into a typewriter and typed on the form letter, if you don't pay, we're going to sue you. And of course that got them sued in New York for making a false threat. A letter vendor prevents that from happening.
Mhm.
You know, when the plaintiff's lawyer says we don't believe that the letters were sent, the letter vendors do a better job of tracking the mailings and demonstrating that things were actually dropped in the mail, and they do a better job sometimes of handling return mail. So I I think that, you know, if all this were a cost-saving mechanism, it might be hard to sell it to judges or juries or regulators, but it's not. It's a compliance tool. And virtually all of the third-party vendors we see used in the industry have some sort of compliance reason for being used. And
Mhm.
certainly the CFPB seems to recognize that. And Reg F, they recognize the benefit these vendors bring to the table.
I definitely agree with that. I think that the specialization of these services is an important factor in terms of compliance, right? And operationally making sure that things are being done correctly, consistently, and managing that process. Like, most debt collection organizations got into the business of debt collection, not into the business of being a mailing house. And I think the ability to leverage a mailing house that is built specifically for that. I was actually visiting a law firm, really just this week, and they had this giant machine set up to be, producing and printing their letters, and all I could think to myself was, this can't go well. It's just too much of a volume of information for one organization to be handling that doesn't have the specialization in it. But as we look at the copycats and kind of everything else that has been flowing, what have you seen in terms of kind of the trends? Did it pick up quickly after the case, or has it kind of been a gradual incline in terms of the volume of copycat suits that you've been seeing?
We're seeing certainly certain firms that stand out as high volume filers. I looked at one firm the other day whose filings comprised one firm, two lawyers, 41% of all the filings, and there are over 200 of them in Florida. Um, and that's just their federal litigation, does not count their state court litigation.
Okay.
So certainly we're seeing, high volume filers to some extent. We are seeing assertions that I think attempt to stretch the Hunstein decision way beyond its facts or beyond the law. So now I'm seeing people saying, well, if you ran a probate search or a bankruptcy scrub, you violated the FDCPA because of Hunstein. Well, that's not really true.
Mhm.
And it's not really true for a couple of reasons. First of all, information that does not relate to the debt shouldn't be treated as a communication under the Act. The Act tells us that a communication means conveying information directly or indirectly regarding a debt. So when I do a bankruptcy scrub and I use a name and a social, I haven't said a single word about the debt to anybody. And there's no
Mhm.
need for me to convey information about the debt to do that scrub or many other types of scrubs. And second of all, the prohibition is on communicating with a third party in connection with collecting. But when I'm doing those scrubs, in point of fact, my scrub is in connection with not collecting. The whole reason I'm doing a bankruptcy scrub is to figure out if I should shut the thing down.
Mhm.
It's to do with my obligation to comply with Title 11, the United States Bankruptcy Code. It's not to collect money. When's the last time you ever collected money off of a bankruptcy scrub?
Never.
Or a deceased scrub?
Yeah.
Or an
SCRA.
SCRA military scrub? You don't do those scrubs to collect money. You do them to not collect money.
Sure.
And I think that being able to say that and get judges to understand it is going to turn out to be an important thing to do. But there certainly are lawyers who are now trying to extend Hunstein beyond letters and into other types of vendors.
Mhm.
And I've had one lawyer say to me, I don't care if your client printed their own letter. I'm still going to proceed because I'm convinced that when I dig deep enough, I'll find some vendor they shared information with.
Yeah, that reminds me of I don't want to call it a proverb, but I've heard this a number of different times in my reputation management business. They get a call from a consumer attorney. If you leave a voicemail, I'm going to sue you. If you don't leave a voicemail, I'm going to sue you. So, I mean, I feel like it's a similar situation to where they're just going on these fishing expeditions, and whatever they find, they'll come up with a case, however weak, just in order to be filing. But that's how they operate. I mean, that's their MO.
Well, I mean, look, let me be fair. Consumer lawyers have clients to represent just like I do.
Sure.
My clients have to comply with the law. The fact that it's inconvenient or difficult is not really a defense. But the point you just made is, I think, a really, really great one because, at least in my experiences, judges don't like catch-22 positions. And when you
Mhm.
say, yeah, I'm arguing that because of what they did, they violated the law, but if they hadn't done it, I'd be arguing that they violated the law. I don't think judges like that. And I think you're very wise to look at that issue.
I mean, it's something that we see regularly when we're doing reputation defense. And, I've looked at and kind of looked at the technology behind some of the websites and tools that they're using to generate these consumers to come to the table. And they've used some really interesting strategies through the years. And it becomes increasingly more sophisticated. It's been our experience that if we start to beat them from an organic SEO standpoint, that they move to running ads, and then we have to run counter ads, and then it becomes this giant game of cat and mouse and back and forth between really our client and the law firms. And generally speaking, these are some of the more reputable organizations, if not the most reputable organizations across our industry. But you can only control what you can control online, and we can only do so much about reviews because we refuse to cross the line. Like, we won't do anything fake. We only generate real um, reviews, real results, those kinds of things. So it's been one of our concentrations. But I've always been curious to kind of see it from your perspective, in terms of, it sounds like you're seeing a lot of the same things with maybe different methods.
Well, and it's interesting to me because when you talk about reputation protection and reputational management, you know, there's really a lot of that inherent in litigation.
Mhm.
Standing on being technically right without getting a judge to understand why that's important can sometimes get you a decision that makes you look really bad, even though you're not.
Mhm.
And I'll take an easy example. Let's take Hunstein.
Mhm.
You've got a medical collector. I could be wrong. I don't represent them. I haven't seen their file, but
Mhm.
they're working for a hospital. I can't imagine that they don't have a business associate agreement compliant with HIPAA in place.
Mhm.
But when you choose to file a Rule 12b6 motion, the court doesn't get to look at other documents. So no one has stood before a court and said, wait a minute, let's stop this privacy nonsense. Health and Human Services issued the regs on what we do to protect patient privacy, and we've complied.
Mhm.
There's no privacy issue here. There's a technical argument about the FDCPA where it might not be completely aligned with what HIPAA expects of us, and it may not be completely aligned with the positions the FTC took in its original staff commentary. But don't suggest that we've been out there just disseminating people's information, because we've put all sorts of protections in place to keep that from happening. If you look at virtually every Hunstein case that I've seen,
Mhm.
they're based on a core assumption that debt collectors are just handing people's personal information out there right and left. That's not happening.
I mean, I see what these agencies are spending on data protection, data privacy, security. I mean, even having me come out and attempt to physically or digitally penetrate their organizations. I mean, they spend a lot of money protecting that information. I agree. I think that the industry itself is not given enough credit for the evolution that it has undertaken over the last, call it, 5 to 7 years, to truly become a bank level security has been the goal. And I think a lot of organizations have made it to that point in terms of the level of encryption, the policies and procedures. I mean, it's really become a much bigger lift for organizations to meet the standards that have been laid out. So it's it's interesting to hear it from your perspective as someone who has to actually defend them in court after the fact.
No, I mean, to your point, 7 years ago, maybe 8 years ago, I remember I had two clients in the country who could pass my simple 7-question data security quiz. Today, most of my clients can probably pass it.
It's changed. I mean, there's been a massive investment. I mean, there's entire compliance departments that are built out now. The IT staff is far savvier. and they've started to separate, previously it was like one local, one IT guy, and now you've got your network people versus your security people versus your web people. But I think that also comes down to the way that technology has evolved over that time period as well, moving from the local premise to the cloud, and kind of that transition and how it's happened. Have you seen anything in the Hunstein copycats in terms of the use of cloud to this point?
I haven't seen one where someone talked about cloud computing as a basis. I think that's truthfully more difficult. We get into things like leased servers and who owns the space, and whether a court's going to say that a leased server isn't your server, which then gets into the question, okay, Judge, well, my files are sitting in my office and I rent my office space. Are you going to tell me that's not secure either? I mean, I think that as long as people do a good job of conveying the concepts to judges, um, I talk to my own team about the role of lawyers as teachers, and it's important to me after 23 years of teaching consumer law at UT Law School. And I think as long as we lawyers remember that part of our job is to be teachers, because judges don't and can't know everything,
Mhm.
we've got a better chance of dealing with those types of issues. But if you don't explain to a judge both practically and conceptually what's going on with cloud servers, you could get a bad decision.
Manny, that is an incredible point. I've never really considered it from that perspective. I really want to just take a minute here and thank you very much for participating in the discussion today. I'm hoping that we can continue this dialogue into the future, especially as we start to roll out some new series and some new information on receivables info. But there's nothing like getting a few minutes with the man who has been through just about everything in this industry and defended a little bit of everything. So, I really just can't thank you enough for your participation today.
Thanks for inviting me. I really appreciate it. It's good talking with you.
Absolutely. For those of you that are watching, if you have any questions or comments, feel free to leave them below. Manny and I will be happy to respond to them. If you have any other topics that you'd like to see us discuss or guests that you'd like to see me interview, feel free to leave a comment below. We're always looking to generate some new content for the industry. But until next time, we will see y'all again soon. Manny, thanks again so much for your time today.
Thank you.